Still missing 4? But Ms. Nelson knows who that is? Okay, great. I let you guys down when you were giving your closings. We've got this camera now, and I forgot to switch to that camera so that everyone could see who was giving the closing. Your last chance, Mr. Hand, and I ruined it. Sorry about that. After all the work they did in getting that in there. Director error. All right, let's get on the record in State versus Christopher. It is the 8th of December, a little bit after 9. We've got our prosecutors here. Mr. Christopher is here. Good morning, sir. And his lawyers are here. We are waiting on a few jurors, but we have at least one thing we can talk about, which is whether certain state exhibits go back with the jury. Anything else, Mr. Hand, we need to cover from the state?
No.
Okay, Ms. Wood?
No.
Okay. Any good news, Deputy Gordon?
One out.
Just one. Who's that one? Genius?
Jenkins.
Oh, Jenkins. Okay, like our special juror, the genius. Jenkins. Okay. Okay. So, let me get that. I have get them in order here. The exhibits that the defense thinks should not go back to the jury are 5, which is the CAD report for Mr. Christopher's 911 call. 14, which is Officer Ramuno's accident report. 15 and 16, which are the arrest warrants. 18, which is the T-Mobile data, and 19, which is the record certification affidavit from T-Mobile. Let's start with we'll go in numerical order, the CAD report. Ms. Wood or Ms. Feely, why should 5 not go back?
We don't have a strong objection to it going back. It does get close to being continuing witness issues. We don't have a strong opinion.
Okay, I'm gonna have 5 go back. How about 14, Ramuno's accident report?
We can do that as continuing witness.
All right. Well, what's the basis for allowing 14 to go back, Mr. Hand?
Judge, 14 has within it a diagram of the incident. It was used during the testimony of Detective Ramuno to illustrate his explanation of what he concluded occurred at the incident. Per case law, specifically Ruffin v. State.
Before I'll short circuit you a little bit, Ms. Feely, if all we did was have page 3 of the report go back, so no narrative, i.e. continuing witness part from Ramuno, any objection to the diagram going back? Okay, that's what we'll do. I'll let you manage the mechanics. Maybe you could get an exhibit label that calls it 14A, or you could even, if you've got another one, I'd like to leave 14 intact and have that stay with Ms. Rivers. And if you just get another page 3, let's call it 14A. 15 and 16 are the arrest warrants. What's the basis for the arrest warrants going back to the jury?
Judge, we don't object.
Okay. They'll stay with Ms. Rivers. 18 is the data from T-Mobile, Ms. Feely, and you've lodged your objections and preserved them as to they weren't timely, or maybe they are hearsay because the data are not regularly kept in the ordinary course of business for T-Mobile. Beyond that, is there a basis for the data as opposed to the certification going back to the jury?
Even though it's not words, it's still like a narrative of a time period, and so we still think it's continuing witness.
Okay, I'm going to allow 18 to go back with the jury. The certification, why would you be sending it back, Mr. Hand?
Judge, I don't think
And why should it go back, Mr. Malkin?
Yeah. Good morning, Your Honor.
Good morning.
Because it states that the records were kept in the normal course of business. It's the normal course of business to keep those records. They're made at or near the time of the event. So it shows that they are just objective records of T-Mobile, and shows they are not any manipulated records by Roswell law enforcement or anybody else, but it's just the raw records that just automatically come into T-Mobile. They might be provided in the way that was requested by Roswell police, but it's the actual true data from T-Mobile, and the jury ought to know that, so they know there's no manipulation. It just ratifies the records and says what the records are, that they're true and correct records of what was requested.
If Ms. Borland, who is the certifying employee from T-Mobile, had, instead of providing this, come to testify and answered all your questions that would have yielded that testimony, a transcript of what she said wouldn't go out with the jury, but the data would. The jury would have heard her say, this is just the information that T-Mobile collects. It hasn't been manipulated. It's a pure extraction of data. Ramuno wanted cell phone records with location information, if available, from date and time X to date and time Y. This is what we gave him. It's no manipulation at all. If Ms. Borland, Bourland, had said those things in the old way, because you didn't used to be able to use these certifications, you, during your closing, could remind the jurors of what she said, but what she said, you couldn't write down on a piece of paper and send it back with the jury. Is that not what 19 is?
A fair question.
Okay.
The state would observe that the state believes there's also a certification for State's Exhibit number 22, the medical records, and there was no objection to the medical records going back. And if there is a business record certification with medical records, there was no objection to that going back with the jury for the medical records. And since there was no objection for that, then this certification ought to go back as well.
Got it. I'm going to keep 19 out. If a question comes from the jury, hey, could we see that certification? Then we may need to bring them back out here and we could put it on the overhead projector, but it will not go out with the jury. So to recap, States 5, which is the CAD report in connection with Mr. Christopher's 911 call from the church parking lot, goes to the jury. States 18, the T-Mobile data, goes to the jury. And 14A, which Mr. Hand is creating now, which is page 3 from Ramuno's report, goes out with the jury. The rest of 14, all of 15, all of 16, and all of 19 will stay here unless there's a question from the jury that would prompt us to share the contents of one or more of those documents. Anything more you want to get on the record, Ms. Feely? Okay. I am being told that Mr. Jenkins is not going to be here until about 9:30. He's an alternate juror. I'm fine charging everyone but Mr. Jenkins, but he'll show up in the middle of the charge. So, Mr. Hand, do you want to wait for Mr. Jenkins and we'll just go forward with all 14, or do you want to go forward now?
Judge, I'm fine with the board.
Ms. Feely?
I'm fine moving forward as well.
Okay. Then let's bring the jurors out, just so we know. I don't want there to be confusion. We have a whole nother alternate who is here. Mr. Jenkins is the first alternate. So if we start without him, we start the charge without him, he won't be the alternate. He can't be the alternate because he won't have received the full charge. Mr. Trice, gentleman with the boot, he'll be our alternate and will be sequestered during deliberations, but he'll be available, and we'll just let Mr. Jenkins go after the jurors start deliberating. You understand that's how it'll play out, Mr. Hand? Okay, Ms. Wood, you okay with that? Great, let's bring the jurors out, please. Brittany Griner traded for an arms dealer. That is interesting. Basketball for arms dealer.
The Merchant of Death or something like that?
Yeah, I'm not feeling it. And the arms dealer was an actual like trial in the United States due process conviction as opposed to what happened with Ms. Griner. But anyway.
Any questions?
I have no answers. I just have the headline. I'm most happy for Ms. Griner and her family. She must have friends in high places to get a swap for the Merchant of Death.
Judge, is it possible to just remove that second page until I can get a second copy that exhibits?
Sure. You're talking about 14?
Yeah, I have one.
Okay.
Great. And yeah, can you come up, please? And I don't know where the evidence is right there. We'll just do that after. You don't need to come up. Just you get 14A ready, and once they're going back to start their deliberations, we'll take care of that. I need to get the jury charge up.
Honorable jurors.
All but one.
All the one.
Good morning, ladies and gentlemen. Happy Thursday. We are on the very, very home stretch of what happens in the courtroom. I need to give you the charge, the law that you must apply to the facts as you find them to be, and then we're going to begin our deliberations. So I appreciate almost everyone being here on time and ready to go. A couple notes about the jury charge. You are welcome to jot down the key points that you hear from the charge. I will be reading from this document, which will go back with you during deliberations. I do my best to make the law that I have to share with you as accessible as possible, so that I can understand it and you can understand it. But there are certain legal concepts that higher courts have said, trial judges, you have to use these words to describe them. So if sometimes my language seems a little stilted, I'm not trying to impress you with big words. Some higher court has said you need to use those big words to explain this concept or that. But you'll get what I am reading from to reread if I move through those concepts too quickly. And it may be that all of it is fully comprehended, which is my goal. So I'll be reading aloud. On the screen will also be what I'm reading. So some folks do well listening, others like to see and hear. So you're welcome to follow what's on the screen. You can listen. You will also get a copy. You'll get this copy, the one I'm holding, for your deliberations. With that, I will give you the charge in the state of Georgia versus Landon Christopher. I can get this working. Let's see. Here we go. A grand jury has indicted the defendant for hit and run. The defendant has entered a plea of not guilty to this charge. The indictment and the plea form the issue that you must decide. Neither the indictment, which you'll have with you during your deliberations, nor the plea of not guilty is evidence. The defendant is presumed innocent until proven guilty. This presumption remains with the defendant unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every essential element of the crime charged. And I'll be telling you in a little bit what the three elements of hit and run are. There's no burden of proof upon the defendant, and the burden never shifts to him at some point to introduce evidence or prove anything. And if a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. Does the screen have that little bar across the top so it's blocking the words? I don't know why that's happening. Yeah, let's see if I can make it go away. Is that a little better? Did it move up? No. The big screen. It has this black bar blocking some words. Oh, small screen. Okay. If you could, Ms. Rivers, on your screen, there is if you go over to the left all the way on that one and then click that small thing. Yeah, click that. Better? All right. I'll start from the top on this screen. The state is not, however, required to prove the defendant's guilt beyond all doubt or to some mathematical certainty. A reasonable doubt means just what it says. It is a doubt based upon common sense and reason. It's the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is not a vague or arbitrary doubt, but it is a doubt for which a reason can be given. And that reason needs to arise from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering all the evidence, you find that your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law, and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crime charged, or that merely raises speculation or conjecture of the defendant's guilt, is not sufficient to authorize a conviction. It's my responsibility to instruct you on the law that applies to this case, which is what I'm doing right now. You are bound by my instructions. It is your responsibility to determine the facts of the case from all the evidence that has been presented. Then you must apply the law I give you to the facts that you find. You must decide this case based only on the evidence presented. That evidence consists of all the witness testimony, and number two, the exhibits that were admitted, which will go back to the deliberation room for you to review. Evidence does not include the indictment, although you'll have it back there. It's just not proof of anything. The defendant's plea of not guilty, anything I've said, or anything the lawyers have said to include their opening and closing remarks. And finally, questions are not evidence. So if one of you asked a question, as in you wrote it down, but it was not ultimately submitted to a witness to answer, that question's not evidence. The fact that the question wasn't asked is the result of a legal ruling and is not evidence. Now, the evidence that you have received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact. We call that person an eyewitness. I was there. I saw the car run a red light. Happened right in front of me. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. That's people walking into the courtroom carrying umbrellas and they're a little bit wet. Probably raining outside. It's circumstantial evidence, but you can't see here in court because we have no windows whether it is in fact raining. There is no legal difference in the weight that you may give to direct or circumstantial evidence. In considering the evidence in this case, you are free to use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether it's direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility or believability of the witnesses who appeared before you in this case. And in deciding this question of credibility, you may consider all the evidence, the witnesses' manner of testifying, their basis for knowing the things about which they testified, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. We call that impeachment, or by demonstrating that the witness said something different on a previous occasion. You may also consider evidence of a witness's bias for or against a party. If a witness's credibility has been attacked here in court, you may consider evidence offered to support the credibility of the witness, to include prior consistent statements that the witness made. You've heard from a witness who was designated as an expert. Experts, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person, someone like you or me. Experts are permitted to give their opinions based on their training and experience. But the testimony of an expert, like that of all other witnesses, is to be given only the weight you think it is entitled to receive. The testimony of a single witness can be sufficient to establish a fact. Corroboration is not required. Criminal defendants who have no burden to prove anything in a trial are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. A crime occurs when the law is violated by a defendant's intentional action or inaction. Intent is an essential element of every crime. Criminal intent is not the specific intent to violate the law, as in, I know that there's this law out there and I want to violate it. But instead, it means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from your consideration of the words, conduct, demeanor, motive, and other circumstances that are connected with the acts for which the defendant is being prosecuted. Venue. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, which is, was the alleged crime, the hit and run, committed here in Fulton County, must be proved by the state beyond a reasonable doubt. So here are the elements of hit and run, the one charge you're considering. For hit and run, the state must prove, number one, that the defendant was operating a motor vehicle that was involved in a collision with a pedestrian. Number two, that this collision caused a serious injury to the pedestrian. And number three, the defendant failed to stop and remain at the scene of the accident until aid was rendered to the pedestrian. Ladies and gentlemen, by no ruling or comment that I've made during the trial have I intended to express any opinion on the credibility of the witnesses from whom you've heard, the strength of the evidence, or the possible guilt of the defendant. Your verdict in this case must be based solely upon your consideration of the evidence, according to the laws that I've been giving you. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. It is also your duty to report to me if you believe that a colleague is making decisions back in the jury room based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You decide what happened. You are not to concern yourselves with punishment. That is my job. One of your first jobs, speaking of jobs, in the jury room will be to select a foreperson who will preside over your deliberations and who will sign this verdict form to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a discussion of the case with your fellow jurors and a careful consideration of the evidence. In the jury room, you will have this verdict form. If, after considering the evidence, together with the charge that I'm almost done giving you, you should unanimously find, beyond a reasonable doubt, that the defendant did commit in Fulton County the crime alleged in the indictment, that is hit and run, you would be authorized to find him guilty. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty. And you would check the appropriate blank on the verdict form. The verdict form says, we find the defendant, and there's the word guilty with a little blank, and not guilty with a little blank. If you do not believe that the defendant is guilty, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him. In which event, the form of your verdict would be, we, the jury, find the defendant not guilty, and you would check the appropriate blank on the verdict form. Whatever your verdict is, it must be unanimous. And your verdict must also be in writing on this form, signed by your foreperson and dated. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any outside research. You have all the evidence in this case. It would be improper to supplement it with anything else. And to assist you in complying with this direction, Deputy Gordon is going to be collecting all your electronic devices, including Apple Watches, if anyone has one, which we will keep safely in my chambers until you're done deliberating. And I promise you'll get them back. Ladies and gentlemen, going forward, should you need to communicate with me for any reason, you have a question about what's going on, or you think you need something else, it must be in writing. Write it down on one of those note cards or on a sheet of paper from one of your notepads. When I get your question or note from Deputy Gordon, I'll share it with the lawyers, and then I will provide you whatever response I am allowed by the law to give. There are certain restrictions on what I can say in response to your questions. Sometimes my response may seem unhelpful because I'll say something like, you have to rely on your collective recollection. And that's me simply saying, that's a you question and not a me question. But if it's appropriate for me to give you more legal explanation or whatnot, I will certainly do it, but just make sure that your questions are in writing so that I can make them part of the record. And with that, I've completed the jury charge, and I'm going to ask all of you, except for Mr. Trice, to return to the jury room. As soon as we get you all the evidence, there's going to be a box with the evidence. It'll have this verdict form. It will have the indictment, and we'll have the jury charge. Once you get all that, you may begin your discussions. Until you get the evidence and this paperwork back there, just get situated, figure out your foreperson, whatever you're going to do. It's only take like 2 minutes, but legally you need to wait till that box comes back to you. You are now in charge of when you break. If your deliberations take you up to lunch, you need to let Deputy Gordon know that. You cannot deliberate when not all 12 of you are in the room. Let me put that a different way. All 12 of you need to be in the room to have discussions about the case. So let's say it's 10:30, you're still deliberating, and someone says, I need a break. That's great. You can choose to have a break. But if at least one of you leaves the room, you stop talking about the case. So just let us know when you're taking breaks, if you need a lunch break, when you're going to do that. And that way I can let the lawyers know they don't need to be right here in the courtroom waiting on you. But Deputy Gordon's going to tell you how to turn the little light on and how to keep in touch with him. And we will be on standby for your questions or your verdict or whatever else may flow from this. Any logistical questions about that? Okay. Thank you so much. Mr. Trice, if you could just sort of step out of the way, they're going to flow into the jury room and talk to you about one thing. Mr. Trice, you can take a seat. This will be short, but I need to let you know your role. You are our alternate juror. So if we lose one of these jurors, there's a conflict, someone needs to leave, or for whatever reason, I need to excuse one of those 12, you will join that group. They'll start their deliberations over, and you will discuss with the remaining 11, convict, not convict, guilty, not guilty, whatever it is that gets discussed back there. But what I need you to do is stay nearby while they're deliberating today. In case I do need to excuse someone, we can plug you right in. We're going to get you set up probably in the jury room over there. That'll be your space. There's a bathroom in there. If this group breaks for lunch, you'll break for lunch with them. You can be with them because they can't talk about the case while they're having lunch. And I promise if they reach a verdict, if I accept that verdict, I'll let you know that that's happened so you can not be stuck here in the courthouse. So we're not going to forget about you, but you are kept separate from that group because you cannot participate in their deliberations unless you become a non-alternate juror, i.e. we excuse someone. If you brought electronic devices or any other property, a book or something, you can go get that and you should gather your stuff and Deputy Gordon will get you to the space that's going to be your own. Does that make sense? Yes. Great. Thank you so much.
Jenkins around too.
Okay, he can come on out. Hey, take a seat. Is you're going to take him around or is he he'll just come through? Okay. Mr. Jenkins, how you doing? Good. What happened this morning?
Due to traffic, I live a whole hour away.
Where do you live?
I live all in Roswell, West Florida.
Okay, way north.
Yes.
Okay. You were one of our, I'll let Mr. Trice come on through. Oh, Deputy Gordon's going to show, I think he's just going to walk you over there. Mr. Jenkins, you were one of our alternates. Mr. Trice is the other. So it's sort of backup jurors in case we lost a juror during the course of the trial because of illness or conflict or something like that. You would slot in as a regular juror. No one knows that during the trial because we need you thinking like you're going to be deliberating. But we decided, because it wasn't clear when you'd be here, that we'd move forward with things and not make the other jurors wait. So what I'm going to do is excuse you because you didn't hear the legal charge that I gave. Should we lose a juror, we could not press you into service because you didn't receive the legal instructions. So no harm, no foul. We actually discussed, do we want to wait for Mr. Jenkins or we know we've got Mr. Trice. You all can be seated. Knowing that we've got Mr. Trice as a backup juror, do people want to go forward? And both sides elected to go forward. So no one is upset. You got stuck in traffic. You're not missing out on deliberating because you were an alternate. Had you been here on time, you would have heard the jury charge. Not very interesting. And then you'd be in that room with Mr. Trice while that group deliberates. So you don't need to stick around because you could not serve as an alternate if we did lose a juror. Does that make sense? Okay. We all appreciate your service. You were here ready to go. You heard all the evidence, paid attention and all that. And that was extremely valuable to us to have two backup jurors in these COVID times. You never know when you're going to lose someone. So we appreciate your service. You'll still get the small daily stipend for the days you were here, and you are free to go. All right? Have a good holiday.
Your Honor, would it be okay if we spoke to Mr. Jenkins if he wanted to talk to us?
It would be okay. I think he'll be coming out. Which way are you sending him out?
He's doing whatever.
Okay. If you could just grab him. Well, you know what? he should have him go back there and just wait for me. Okay, thanks. He can gather his stuff. Yeah, tell him not to leave. Do we have 14A? Great. If you don't mind coming on up, let's briefly go off the record so I can hand things to Ms. Rivers. So these are not in evidence? I mean, they're in evidence. They're not going back with the jury, to be clearer. And then what you have in your hand, and those two do go back with the jury, along with verdict form, indictment, and jury charge. So is it safe to say what's in the box is what goes back?
Yes.
Excellent. Okay. So I'm gonna go find out if Mr. Jenkins wants to talk. I'm not gonna have him sit out here and tell us that. This doesn't need to be on the record. When I get back, we'll get on the record any exceptions to the jury charge. We'll talk about logistics for waiting for deliberations. And I'll let you know what Mr. Jenkins wants to do. So sit tight. All right, let's get back on the record. We have juror 23 here who I just need you to explain, Mr. Burfield, what you told Deputy Gordon so we can get it on the record and I can make sure counsel understands the situation as well. So if you'd explain to me, it sounds like you need not one, but two cell phones with you during deliberations?
One of them is not actually a cell phone.
Okay, so walk us through. I know it relates to the type 1 diabetes, which you flagged during voir dire. And hopefully so far we've been able to largely accommodate for you. Good. Okay, so the two devices.
Yes, I wear two medical devices, one to constantly monitor my blood sugar, which could put me in a dangerous state if it goes too high or too low and could cause, immediate harm or death. That connects to this.
This being, okay, so a device on your person communicates with your cell phone.
Exactly that.
And if it is sending an alert, it goes to your phone, you don't hear a beep, you don't get a buzz on your side. You need your phone to deliver that news to you.
In addition, it needs to be within a certain amount of space for the Bluetooth to connect to the device on my body.
Okay,
This is the insulin pump. It is actually physically a Droid phone, but it does not have any phone capabilities, phone radio, any of those things. This connects to the actual insulin pump where I can dial in to give me insulin when.
so your Apple product says, hey, you need to do something, and then your Android product enables you to do the something your Apple product is telling you.
The Apple Watch gets the blood sugar from the phone, but that's more of a nice to have because I could still use the phone to see the blood sugar.
Okay, so your commitment to us, which you'll get on the record in just a moment, is that you will not use your iPhone for any research purposes. In fact, you don't even need to handle it unless you're getting an alert from the device on you that there's a medical issue. Is that a,
Things a little more comfortable for everyone, I could even put this on airplane mode as long as I activate.
Let's do that. That'd be even better. Airplane mode, activate the Bluetooth, and give Deputy Gordon your Apple Watch.
Sounds fair to me.
Excellent. Any issues with that, Mr. Hand? Ms. Wood?
There.
Okay, I appreciate you sharing that, and I'm glad we're able to accommodate all that. And that's the evidence. So when you bring Mr. Burfield back with that box, they can start. All right. Mr. Jenkins has indicated he's comfortable chatting. Here's how it's going to work if we're going to do it. I'm going to ask Mr. Christopher and one of his lawyers to step outside, and one of his lawyers can stay. And then Mr. Jenkins, you are, we can go off the record now. We're going to put the Zoom system on jurors are deliberating. I'll mute the audio, and then we'll talk some more. So hold on one sec.
And we just have, early, just, yeah, thank you.
Mr. Han ran to the restroom. He'll be right back.
Okay, but we just need Mr. Christopher. We've got plenty of lawyers. Get Mr. Christopher.
Good a question.
4. All related.
I was down the hall, I'm sorry.
No problem. All right, Ms. Rivers, are you ready?
Yes.
We're back on the record in State versus Christopher. There are 4 questions from the jury. I'm going to read all 4, and then we can talk about possible answers. One, they're all from different jurors based on the handwriting. They don't identify themselves, but looks like 3 different sets of handwriting, 2 questions from one juror. The juror with 2 questions. First question, was the witness list with addresses public info before the trial? Second question, would Mr. Christopher have access to the witness list before the trial under normal circumstances? So questions about the witness list. The third question, second note card, where does L. Christopher currently reside? And finally, the fourth question, third card, will our personal information be shared publicly or retained in any way? So I'm going to work backwards. Will our personal information be shared publicly or retained in any way? I intend to write on the back of the card. It will not be shared publicly. It will be retained under seal. It's a true statement. Any objection to that, Mr. Hand?
Okay.
Ms. Wood?
No, you're right.
All right.
Could we also add, Your Honor, that nobody has their information?
As in, I mean, I do, but
Well, I mean,
what was disseminated was returned.
correct, that none of the attorneys or litigants or interested parties have their information because it was all collected back by the court.
Sure. I'll draft something and read it to both sides and you can let me know. Where does L. Christopher currently reside? I'm going to write something to the effect of that's not available, but I don't want to make it sound like I don't know or it's secret. It's none of their business. If you all want to have me tell them what city Mr. Christopher lives in, we can do that. I'm open to that. It's not in evidence, but it may even be in evidence. It may be I don't remember. If Kayla Newborn said, I think he lives in Roswell. What would you want me to say in response, Ms. Feely?
Because I think saying that it's not available is.
Right. I would need to say like it's none of your business, but say that politely. Any objection to me indicating to the jury that Mr. Christopher currently resides in Roswell?
The only concern, Your Honor, is that it appears that there's concern by at least some of the jurors should they convict, that they could be the subject of some retaliation. And we know that there are at least a couple of jurors that reside in Roswell because they're familiar with the area. And so
What if I say the metro Atlanta area? I don't think we need to give a specific town, but metro Atlanta area,
that works for
that may strike the right balance. I don't know what's behind the questions. I don't disagree with your reading between the lines on this, in particular in connection with a couple of the other questions. But I think it's probably more neutral to, rather than say unavailable, say metro Atlanta area.
We would prefer Roswell if possible.
Okay, I'll take that under advisement. Was the witness list with addresses public info before the trial? I think it had been filed. It was in the docket. So the answer would be yes. And then would Mr. Christopher have access to the witness list before the trial under normal circumstances? Also, yes. Anyone could have gone into Odyssey and pulled up the witness list because the state, didn't you file?
I did, Judge, but normally for witness lists, I click that button that says non-public. I don't know how that actually translates to the docket, but I thought it would, because it does have people's personal information on
It does.
I would assume it.
Okay.
I filed, it would not have made it a public.
That could be, I have this distorted, not in a negative way, view, because if I go into the docket, I can see what's in there. Your non-public box wouldn't prevent me. That's how I got the witness list, is I went into Odyssey and clicked on it. And now I've got it. So I don't know if there's a way you all can test it. Why don't you do that while I'm crafting responses to these others?
And I'll note, to even search the docket as a citizen, you have to have login information.
Okay, but you could go to the 5th floor of the clerk's office. There are Odyssey terminals there. So it's just a question of if you went there and plugged into Mr. Christopher's case, do you see the witness list as an item? And if you click on it, can you get the info?
So there are some that have little lock pictures on there. I can still click them, but I think that's what that means. And the state's witness list does not have
Okay. It does not have the lock on
that.
it.
It just has the little PDF.
Okay.
I'll double check.
But it's public record either way.
It does come up, Judge.
Okay. So much for checking that box.
There's nothing for me.
Okay. Will our personal information be shared publicly or retained in any way? Your information is not and will not be publicly available. Moreover, the information the lawyers received has been returned and destroyed. Does that work for the state?
Yes.
Yes,
thank you.
sir.
Ms. Wood?
Yes, Judge.
Where does L. Christopher currently reside? Mr. Christopher resides in the metro Atlanta area. I know that's okay with the state. And your preference, as between the three, not available, Roswell, metro Atlanta area, you prefer Roswell. As between not available and metro Atlanta area, preference. Okay. Was the witness list with addresses public info before the trial? And would Mr. Christopher have access to it before the trial under normal circumstances? The witness list was publicly available inadvertently, and Mr. Christopher would normally have access to it. Any objection to that, Mr. Hand?
What do you mean by inadvertently?
You didn't mean for it to be publicly available, but it was.
Can we say it that way? Because if I have a question about it, then I assume the jurors would.
They can always write another question. I think this is going to address their concern. Any issue with that, Ms. Feely?
We just prefer the answer to be yes and yes.
Just, we would prefer the inadvertently. It wasn't intended to be.
Okay. This is a long way of saying yes and yes. So I think you're getting what you want. Just I was too wordy, but I also already wrote it out.
I mean, it's public record. I don't even know what box. I haven't seen anything filed in this court that has the little key on it, or the little lock on it.
It should, when we file, we have to file my staff has to file the jury attendance sheet when it's all over, so that on appeal, if you needed to figure out who was on the jury or some issue, if there was a claim that it was Mr. Hand's cousin, that it gets the lock on it, and you can't see that.
So our concern is that the inadvertently makes it look like we had access to it. We had access to it, and we shouldn't have.
I don't mind getting rid of inadvertently. Any issue with removing that? Okay. So what it reads is the witness list was publicly available and Mr. Christopher would normally have access to it. All right, let's get those back, and you'll let them know the answers are on the back. Thanks. Ms. Rivers, you ready? Okay, we're back on the record in State versus Christopher. Deputy Gordon tells me that the jury has a verdict. Is there anything we need to cover, Mr. Hand, before we bring the jury in?
No, Judge.
Ms. Wood?
No, Your Honor.
Okay, then we'll bring the jury in. I'll receive the verdict, and based on what they have to say, we'll make a plan for what comes next. You can bring him in, please. Mr. Trice should sit tight until the verdict has been fully accepted.
All right, adjourned.
Thank you, Deputy Gordon. Ladies and gentlemen, it's my understanding that you all have reached a verdict. Is that correct? Okay. Who's the foreperson? You are, sir. Has your jury reached a verdict?
Yes, sir.
And was that verdict unanimous? And have you signed and completed the verdict?
Yes, sir.
Can you get that to Deputy Gordon, please?
Sir. You.
Mr. Foreperson, it is now time for you as the duly elected foreperson to publish the verdict. And all that means is that you read into the record what the verdict of the jury was.
As the count one hit and run, we find the defendant guilty. So say we all, 8th day of December, 2022.
Great. Thank you very much. Deputy Gordon, if you'll get the verdict to Mr. Hand and then to Ms. Wood. Mr. Hand, do you have any objection to the form of the verdict?
No, Judge.
Ms. Wood?
No, Your Honor.
Okay. Mr. Hand, anything else from the state before I release the jury?
No, Judge.
Ms. Wood?
We'd like to poll the jury.
Okay. Ladies and gentlemen, this is a standard procedure that occurs after a verdict. What I'm going to do is call each of you by name. When I call your name, if you would stand up, I'm going to ask each of you the same 3 questions. I need to do that for each of the 12 of you. I'm just going in numerical order. So Mr. Perdue. It's afternoon. Good afternoon, sir. And you all can be seated. You're welcome to stay standing, but you're welcome to be seated. Mr. Perdue, was the verdict you heard here in court your verdict in the jury room? And is that a verdict that you freely and voluntarily entered into?
Yes, sir.
Is it still your verdict?
Yes, sir.
Thank you. Mr. Holliday, was the verdict read in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into it?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Mr. Holmes? Was the verdict read here in court your verdict in the jury room?
Yes, sir.
Is that a verdict you freely and voluntarily entered into?
Yes, sir.
Is it still your verdict?
Yes, sir.
Thank you. Mr. Jones? Was the verdict that you read here in court your verdict back in the jury room? Is that something you freely and voluntarily entered into? Still your verdict?
Yes.
Thank you. Mr. Shelton? Was the verdict read here in court your verdict in the jury room?
Yes, sir.
And did you freely and voluntarily enter into that?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Ms. Ranson? Was the verdict read in court your verdict in the jury room? And is that something you freely and voluntarily joined?
Yes, sir.
Is it still your verdict?
Yes.
Thank you. Ms. Balconi, was the verdict read in court your verdict in the jury room?
Yes, sir.
And did you freely and voluntarily enter into that verdict?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Ms. McDonald, was the verdict read in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily join that?
Yes, sir.
Still your verdict?
Yes, sir.
Thank you. Ms. Balagoon, was the verdict read in court your verdict in the jury room? Did you freely and voluntarily enter into it? Is it still your verdict? Thank you. Mr. Burfield, was the verdict read in court your verdict in the jury room?
Yes, sir.
Did you freely and voluntarily enter into that?
Yes, sir.
Does it remain your verdict?
Yes, sir.
Thank you. Mr. James, was the verdict read in court your verdict in the jury room?
Yes.
Did you freely and voluntarily enter into it? And is it still your verdict? Thank you. And finally, Ms. Howard,
Yes.
was the verdict read in court your verdict in the jury room?
Yes.
And did you freely and voluntarily enter into that verdict?
Yes.
Is it still your verdict?
Yes.
Thank you. All right, Mr. Hand, anything else before I excuse the jury?
No, Judge.
Ms. Wood?
No, Your
Ladies and gentlemen, in a moment, you're going to return to the jury room. Mr. Trice will rejoin you. You'll get your electronics back, and I'm going to come back there to thank you personally. We have letters for each of you documenting on official court letterhead that you've been here all week for your employer or your significant other or for wall mounting, whatever you want to do with it. So we'll get you that. If there is any pushback from an employer, where were you? What was this about? You're welcome to direct your employer to me, and I'll help straighten them out. On behalf of the state of Georgia and on behalf of Mr. Christopher, I want to thank you for your service. This was a several-day-long trial and a difficult time of year for many people. We know from voir dire, several of you, this was the worst time that could happen because of what's going on at work. There's never a convenient time to be pulled away from life for 3.5 days. But you gave your time for a very, very important cause. And thank you for that. I wish we could do more and give you $25 a day, but such is county stipend for jury service. I'll be back there in a minute. You'll get your electronics back, and we'll wish you the best. Thank you.
Thank you all.
Should have known you'd have those. I always forget about these. Mr. Hand, is there any reason we can't move to sentencing right after I chat with the jury?
I don't see why not, Judge.
Okay, Ms. Wood? Of
Honor, I would just like a few minutes to speak with my client.
course, I'm gonna be gone for a few minutes, so you'll be able to do that. And then when I come back, we'll handle sentencing. I will let the jurors know that, one, they're welcome to watch sentencing, and two, that the lawyers would like to speak with them. So if they want to stick around, they may. You'll know they're sticking around if they come and sit in the jury box, but they may choose to wait in the jury room, in which case I'll tell you they're jurors who do want to provide feedback or are willing to entertain questions once sentencing is done. Okay? I'll be back. Thank you.
Okay, that's fine.
Here's Mr. Rice.
I'm gonna take those copies now.
Okay, thank you.
Before you leave.
Yeah.
somebody saying with you?
Yes.
Okay, just have a seat. You need to get it. Got anybody gonna come in or you gonna take it? This is all his separated? Yes. Hold on, I'm bringing this stuff.
I need to pass me the one.
Oh, we want to speak back to you. Okay. Which one you want to speak to? You over here? Both of you? $13,000, 1360.
So he can't be ordered to pay any restitution if there's no probationary part of his sentence, so you don't need to ask for any restitution.
Okay.
It wasn't anything anyway. If we had an intention of paying, there would have been some negotiation going on. How about 2,000? You know.
But I thought she was here another one.
It's not enough.
I didn't see it.
Okay, I will do it.
I got it.
Okay, yeah, who's this?
I got this in the box.
Oh.
Was sentenced pursuant to the drug course. So this one, the completion of sentencing, and all these for the completion of sentencing and for sentence witnesses.
No, I'm good at the moment.
Last one, judge what his sentence was. And to serve 4.
Which one was that?
6. So he got 10 years, okay, with 4 years to serve and 6-year probation, so it's 10 to do 4. 10 to serve 4. So he certainly should go. Yeah. So he certainly should not receive less than that. So it's really,
I have a question for you.
All four automatically should. All four individual sentences. The way that subsection C. A specific. For an aggravation, all for aggravation.
Yeah. Okay. I'll just figure out how to do that on my sense.
Three are in, okay, aggravation and, okay.
Then he doesn't
So
work.
that's one time.
I'll look and see.
Responsibility and accountability. Is there more? Yeah.
Court will now come to order. Maybe seated.
We need Mr. Christopher, and then they need you in the jury room so you can do it in whatever order Sarge tells you to, but the jurors want to just say goodbye and thank you to you. So if that has to happen first, go aw shucks and sign the autographs.
Thank you for helping us.
I can enter an order. I think what you can do in the final disposition is say directed verdict.
Guilty to murders.
I think we'll be all right. Why are you blushing? All right, Ms. Rivers, are you ready? Okay. We are shifting now to the sentencing of Mr. Christopher. The jury found him guilty of the one remaining count of the indictment, which is felony hit and run, serious injury. Count 2, I entered a directed verdict on, and that will be reflected in the final disposition. Mr. Hand, I'm ready to hear from you as to what the state recommends in terms of sentencing for Mr. Christopher.
Yes, Judge. Is there a preferred placement for me to talk to the court? Can I just go?
As long as Ms. Rivers can hear you, as usual, you can be where you want. I wouldn't be up at the witness stand, but where you are or the podium is fine.
I'll go from here, Judge.
Okay.
Judge, the state is requesting a sentence of 5 years as a recidivist under OCGA 1710-7 subsection C. A notice was filed with the court notifying the court as well as defense counsel that the state was seeking to recidivize the defendant based on 4 prior felonies convictions. And that also been discussed with defense counsel as well. Judge, at this time, I'd like to go over those 4 convictions, so the court will know what they are, as well as tender them to the court.
Okay,
Judge, I have begun my exhibits starting at 23, just to continue.
okay.
Is that appropriate? Is the court okay with that?
Yes, that will be helpful.
Judge, the first conviction is all of them are Fulton County convictions. The first one is case number 08SC70389. And that is a conviction March 12th, 2012 for possession of cocaine with intent to distribute, as well as a misdemeanor contribution to the delinquency of a minor. Judge, this one is only tendered for aggravation purposes.
The one ending in 389?
Yes, Judge.
Okay, and why only aggravation purposes?
Judge, that one is marked as a first offender plea.
Okay,
Drug court pursuant to 1613-2.
all right.
Drug court, first offender bill. However, the remaining 3 are for aggravation as well as
Recidivist?
subsection C, recidivist.
Okay,
The next one, Judge, is case number 08SC72566, where the defendant pled guilty to terroristic threats. And we note, Judge, that threat was threatening someone with murder, Judge. That person being Mr. Richard Banks.
okay.
The third conviction, Judge, is case number 09SC81941. That conviction was for 3 counts of aggravated assault and 4 counts of aggravated battery. The sentence for that, Judge, was 10 years. To serve 4, Judge, to serve 6. Wait. To serve 4. So 4 years in custody, 6 years of probation.
Is what you're going to share with me the final disposition only or also the indictment? It's the whole packet?
Yes, Judge.
It's been a minute, but I think it's supposed to be indictment and disposition.
It is, it's both.
Okay.
And from that one, Judge, that case involved, that aggravated assault involved him striking individuals in such a dangerous manner that it resulted in aggravated battery, depriving different individuals of different parts of their bodies, hands, feet, and fists, Judge.
Striking with what? Oh, with his hands and feet?
Yes, Judge.
Okay.
And for another victim, his nose as well. The last conviction, Judge, is case number 11SC102143, where the defendant was convicted of possession of cocaine. That sentence, Judge, was 10 years total, 4 years to serve, and 6 years imprisonment. And I bring that to your attention, Judge, because we're requesting 5 years and for a sentence for drug possession, the defendant has already received 4 years and in this case, continue to possess drugs. And so hopefully a tougher sentence of 5 years will deter him from continuing to break the law. So I will tender those to the court at this time.
Okay.
It's exhibits 23, 24, 25, and 26.
All right. Ms. Oh, you're going to take a look at them first.
Yes, Judge.
I forgot to show them to you. Sorry.
Do you have any victim impact information from Mr. Duffy beyond what we got to hear through his 911 call and his testimony?
I do not, Judge.
In the indictment? Yeah. So that's the July.
I think the court has discretion about this, and would look at the totality of the circumstances, but it appears that 3 of these convictions he was in the Fulton County Jail for at the same time and then pled out on the same day. So
Right.
ask the court to consider that as one instead of having it be 3.
Okay, so I will look at the paperwork now that Ms. Wood's done what it, if someone would hand it to me. I know that there are times when a judge can annotate on the final disposition consolidated for purposes of sentencing. And it can have an effect. It's usually when someone's trying to get a first offender off of more than one offense, more than one conviction, meaning different indictments. But it is that person's first time dealing with criminal charges. We also have lots of times when we take pleas in multiple cases for a defendant all at once, and they're separate convictions. We're just trying to clean things up for the person. If it's clear to me from the paperwork that this is not the first offender part of it, but that this was meant to be consolidated, then we'll need to talk more about it. But I'm going to just flip through it. That's one reason why I wanted to see the paperwork.
Considering the first offender that was successfully completed?
No, but it does complicate things a little bit for your argument, because I think, well, hold on one second. I think the dates on the recidivist notice are wrong. So the first offender was actually a plea on August 1st of 2008. Is clearly separate from the other 3. And if it was successfully dealt with, then it's not a conviction. I think I can think about it in terms of aggravation. Let's look at the other 3. So the terroristic threats was clearly distinct from any of the others. It was on the 28th of March in 2011. So that is a felony conviction, no first offender, no consolidation. So the final two, so states 25 and 26, I don't find that they were meant to be consolidated for purposes of sentencing. The disposition in 11 SC 102143, that's the cocaine case, simply says that that sentence is to run concurrently with the aggravated assault case. So it is a separate conviction in a separate case. The pleas were taken on the same day, but they are distinct, and so I think count as separate felony convictions. So one, I find these are admissible as certified copies. It's got the fancy raised seal on the back of all four. Two, states 23, the first offender, I don't have any evidence that says he didn't successfully complete it, so it would be at most aggravation. You're not trying to use it, Mr. Hand, to trigger a recidivist provision. But states 24, 25, and 26 appear to be valid, distinct, separate felony convictions, which gets us into 1710-7C. Ms. Feely, anything else you want to get on the record in connection with those?
No.
Okay, Mr. Hand, anything else?
Yes, Judge, I'll continue.
Please.
Judge, the state is requesting the max of 5 years for a couple of reasons. One, this crime that was committed by the defendant was very intentional. Everyone heard testimony today, well, throughout this week, about how the defendant, after he struck Mr. Duffy, at some point found out that he was a human was laid out on the ground, and then proceeded to get back in his vehicle and leave. That was after only coming back to find his mirror, not to figure out if someone was hurt or harmed, and that was super intentional. The other piece that makes this, we're requesting the max for, it makes it so bad, is that the defendant then tried to cover up that happening, not by just lying himself after leaving the scene, but then forcing another individual who's a witness to what happened to lie as well, and that would be Ms. Kayla Newborn. He not just told her what to say to the police, but he also told her to turn off her cell phone. He didn't take her home. It was tantamount to a false imprisonment type of situation where until he could figure out his cover up, he influenced another witness that only recently felt more comfortable coming up and telling the truth, Judge. Also, even upon Ms. Newborn deciding to say the truth and tell what happened, the defendant continued to refuse to take responsibility and come forward and state that he was guilty, in having us to go through a whole trial where a jury had to sit through and hear all the evidence, which is his right, Judge. However, there was a refusal to take responsibility as well. And lastly, I'd like to end on the impact to the victim. Mr. Duffy had surgery on his ankle that, per his statements today, he still has pain with every now and then. Also, the injuries that he had to his face that evening, the blood that we saw on the body camera footage showing how seriously injured he was and how traumatic the event was for him. He awoke and he didn't know where he was, and he didn't know why there wasn't anyone there to help him. What he did notice is that he was still near the roadway and he could have been struck again. We also heard how he was crying on the phone to the officer, and even after officers arrived, how frazzled and frantic he was, even to say that he thought he was going to die. And so we're not requesting any restitution, Judge. That's mainly because the defendant has already indicated that he's on a fixed income, also no intent to pay by him even not wanting to admit guilt to doing the act. And so we're just requesting the max of 5 years, especially given the criminal history, to ensure that there's justice brought to the victim.
Okay, thank you.
And that's 5 years to serve in custody, Judge.
Understood.
Thank you.
All right, Ms. Wood, Ms. Feely?
Thank you, Judge. Mr. Christopher is 34 years old. He's a lifelong resident of the metro area. He resides in Roswell. That's where his family lives. He has one child, a 14-year-old. Judge, he does have his GED. He's previously worked as a server at IHOP and at other locations in the service industry. He's currently disabled. He suffers from a number of various health issues, so we wanted to let the court know about those. Judge, I do want to let you know he has served a total of 49 days for this. He served under booking number 2101205, the February 1st, 2021 through the next day, February 2nd, 2021. And then he was also arrested for a probation violation based off of this case under booking number 2105142. That's April 20th, 2021 through June 5th, 2021 for a total of 47 days on that time. We would ask the court to consider those 49 days to go towards credit for any sentence the court may impose.
And that second window of time, span of time, was because of a probation violation
Correct, Judge.
triggered by the arrest in this case?
Yes.
Okay.
The warrant was specifically based off of this case.
So
Judge.
Mr. Christopher was on probation for one of the cases we heard about. Maybe let's just pretend it was the cocaine case. And it finally trickled through to probation. While on probation, Mr. Christopher was arrested for another offense. And that was the basis for maybe 47 days worth or whatever it is.
Yes,
Okay.
correct, Judge. Judge, I do understand the state's request for sentencing in this. However, Mr. Hand highlighted that, yes, Mr. Christopher absolutely exercised his right to go to trial in this case, as we all should be able to. So I don't believe that the court should entertain a trial tax for that choice. I want to reiterate the state's offer literally 2 minutes before we picked a jury was straight probation. And so to flip that and ask for 5 to serve after the end of this week just seems a little extreme, Judge. We are asking the court to consider 5 years probation, serve 1, reduced to the 49 days that he has served, and then he will have the rest of the time to serve on probation.
All right. Mr. Christopher, this is your sentencing, which means you have a right to add anything you want. You may tell me Ms. Wood has laid it out there just like you want it to be, but if there's anything more you want me to know, this is your chance to share that.
I do, Your Honor.
Okay.
I just want to address the court. I think the court may have missed something in the evidence. Mr. Officer Ramuno, he said, Landon, he said, who is that, Landon Christopher? Oh, I hate that son of a bitch. I hate that guy. And I don't think the court saw that. And I just want to put that on the record. An officer that arrested me, he also said that Miss Kelly Hooper also said that she didn't say what he alleged that she said. And you can clearly hear in the recording that he called me a son of a bitch. And he said, I hate that guy. And he was the same officer that arrested me. And I thought the court should have took notice of that. I just wanted to put that on the record.
Okay. Well, I appreciate you sharing that, Mr. Christopher. I don't know that I heard the last part, but I certainly did hear Officer Ramuno express that he knew who you were. I'm not doubting that he said the other thing too, but I'm remembering the situation you're referring to. It was on the radio or something, and they reached out to Ramuno to say, hey, we found the Highlander that we think was involved in the hit and run. So they're in the church parking lot, and you can hear the voice saying, oh, Landon Christopher. And he may well have said the additional piece. Apparently you and Mr. Ramuno have some kind of history. I'm also aware that you have had some interactions that you felt were not professional on Roswell Police's part. That was something the jury didn't get to hear, but you and I got to hear it. Some of the exchange you had with Sergeant Fortunato with the bad apples, and you were highlighting that you may have been profiled in the past. And if that happened, that's not appropriate. And I can understand why it affects your view of how Roswell Police may do things. I noticed that all the officers were white not a particularly diverse police force in a community that is quite diverse now, Roswell. None of that changes what we're working through, though. I have nothing before me that suggests Ramuno planted evidence. I've got nothing before me that says Ramuno influenced Kayla Newborn to say one version of events or the other. And more importantly, it's the jury that found you guilty. And they heard what you heard, what I heard. So they may well have heard Ramuno say that. They certainly got to evaluate everything that was presented, and they came back to a person. It was a very diverse jury, finding you guilty of the hit and run. And so that's what I need to process. Mr. Hand, now really isn't the time? What, is there something?
Judge, it was related to the credit for time served.
Okay, we can do that in a minute. Okay. Mr. Christopher, I'll note that the criminal history I learned about is old. The criminal history that I heard about is old, 8 years old at the time.
Been in trouble now 10 plus years, Your Honor.
That's what I'm getting at here. The criminal history to me serves more as this trigger for the recidivist statute and not so much of, oh, here he goes again. In 2019, there was a DUI. In 2020, there had been a break in the action, and you were up to things that weren't getting you in trouble, which is good. But what we have that night was drinking and driving, and most serious of all, leaving Mr. Duffy lying on the side of the road. And we are all blessed, his family most directly, but we are all blessed that the injury that befell him was survivable. My guess is if you had been 3 inches over, or he, Mr. Duffy, had been 3 inches over, we might be dealing with vehicular homicide and not hit and run. I'll note for the record that a few minutes before the trial started, maybe the state was offering probation. The state was also trying to dismiss this case so they could re-indict it the way perhaps it should have been indicted originally, to include the felony offense of serious injury by vehicle, which carries with it a 15-year penalty. But that's not how this one played out. I have to keep in mind at all times proportionality in sentencing. A sentence of 5 years, which is what the state is asking for, is the most severe sentence I could impose under this statute. If you had killed Mr. Duffy, I could not give you more than 5 years. So I'm not going to give you 5 years. I think that I need to reserve, you shouldn't act relieved yet. I'm not giving you probation either. But if I gave you 5 years and 6 months from now, I've got another hit and run, and for whatever reason, the state only charges hit and run, and the driver killed the pedestrian, I couldn't give that driver a more severe sentence, and his sentence and yours wouldn't be proportional. So I need to be mindful of the endpoints of the spectrum. I think that probation is more disproportional than 5 years. To Mr. Hand's observations, this is a situation where I find, and the jury found, you left someone suffering by the side of the road. You saw the police coming, perfect time to render aid and make sure he's okay. You got out of there and then engaged in multiple levels of cover-up to include coercing Ms. Newborn to join in your cover-up. And that was all in an effort to throw the investigation off you and onto some unknown individual, which would leave Mr. Duffy with no closure. So I think this is a particularly egregious case because of the cover-up and the deceit. Fortunately for Mr. Duffy, the injuries are on the relatively minor side. He was able to walk in here. He's still working. He'll have a lifetime of discomfort with the foot injury. But in the grand scheme of things, no internal injuries, all that kind of stuff. As I sift through that and think about where on that 5-year range this case ought to fall, I'm going to sentence you, Mr. Christopher, to a term of 4 years to serve. It will be pursuant to OCGA 1710-7C, and you will get credit for the 49 days that you've already served. And I think that's it. Mr. Hand, you wanted to say something about credit for time served.
Yes, Judge. The state is requesting only the first 2 days that he spent in jail to be given to him if he is entitled to those 2 days.
Okay,
Just because they were for this case. The other 47 days, I believe, were because of the revocation.
understood. Fair request. I'm denying that request and will indicate on the final disposition that Mr. Christopher should get credit for those 49 days. Mr. Christopher, I need to tell you a little bit about your appellate rights. A jury found you guilty. I've now sentenced you, and you have the right to have the Court of Appeals review the trial as well as the sentence that I have imposed. If you want to appeal your conviction and sentence, you have 30 days from today to file a notice of appeal, which is really just one piece of paper saying, wait a minute, I want to appeal. You also have the right to have a motion for new trial heard when a lawyer, and it won't be these lawyers, you'll get a separate lawyer, and you're entitled to have one handle all your direct appeal through the Court of Appeals and beyond if it goes further, to include this motion for new trial. But a lawyer representing you will be able to argue to me, wait a minute, here were mistakes during the trial. Here were things that Ms. Wood or Ms. Feely should have done and they didn't, or that they did, they should have done a different way. If you pursue a motion for new trial and it's denied, you still have a direct appeal to the Court of Appeals. So you can do both. You don't have to do both. You can do none. That's a discussion for you and your lawyers to have. I am asking them to maintain their lawyer-client relationship with you until you have that discussion, you give them direction, and they will file for you either the placeholder motion for new trial or the placeholder notice of appeal. If neither of those is filed within 30 days, your conviction is final, your sentence is final, and the only other form of relief you have is what we call habeas relief, which is technically on the civil side. You don't have a right to an attorney, and you've got 4 years from the date your conviction becomes final to pursue that yourself, unless you can hire an attorney. You can always have an attorney if you can afford one. But for your motion for new trial and for your direct appeal, an attorney will be appointed to represent you, one who is independent of Ms. Feely and Ms. Wood's office, so that that person can focus a critical eye on, well, wait, maybe your lawyer's messed up. Usually it's, what did the court do wrong? I'm ready to hear that. And we would work through all those issues, either through the motion for new trial or the direct appeal or both. Do you understand your appellate rights?
Yes, Your Honor.
Okay. Ms. Wood, will you have that conversation with Mr. Christopher and file on his behalf if he asks you to do so, either that placeholder motion for new trial or the notice of appeal?
We get to have that discussion and I will file a motion for new trial today.
Great. Well, that'll be 29 days earlier than it has to be, but that'll lock it in place. And then it will be a little while, Mr. Christopher, because we've then got to get a new lawyer appointed for you. We need to get the transcript from the trial. Your new lawyer will review the transcript, talk with you about it, and then file what we call a particularized motion for new trial that'll spell out, hey, these are the mistakes that were made that mean Mr. Christopher ought to get a new trial. You cannot be tried on the false report of a crime. That is forever dismissed. The only thing that could come back if something comes back is the hit and run. Mr. Hand, anything else we need to get in the record?
No, Judge.
All right. Well, I want to thank the prosecutors. I want to thank the defense attorneys for their work on this case. It was an important matter, important obviously to Mr. Christopher, and as well as to Mr. Duffy. If there's nothing else, we are adjourned.
Thank you, Your Honor. Thank you, Ms. Rivers.
Portland. No.
Thank you, Ms. Nelson. I see you there.
Ms. Rivers. I'm only supposed to give you duplicates of the media, right? Okay, so I have all the body camera. I need to give you copies of the 911. When can I do that? Can you do it? Okay. Where do I bring it to? Will you be right here? Okay, all right. All right, I'll bring, thank you.